Now I want to talk about minor consent. So a minor is any person under 18 years of age who has never been married and who has not had his or her minority status changed by the court. So a minor cannot consent for care on their own. So who can give actual consent? And this is either informed, this is basically informed expressed consent. So the parents, the legal guardian, any grandparents, adult brothers or sisters, and adult aunts or uncles can be given informed and can provide expressed consent. If nobody's present to give expressed consent, then we treat under implied consent. So this would be life or limb threatening or potential. Because again, as EMTs and medics, we're not trained to recognize all potential life threats. So if there's any sort of potential, anything that could be a concern, we can treat them. This would also be basically there's no parent there to refuse for them. As far as refusals for minors, parents and guardians have the right to refuse treatment or transport. Note, this says parents and guardians. This doesn't necessarily say brothers, adult brothers or sisters. It doesn't necessarily say aunts, uncles. Parents and guardians must be informed of injury and illness, risks, benefits, treatments, and alternatives. So just like a non-minor patient, you inform the parent or guardian of what's going on. And then you get their signature and get a witness to sign and then document. So make sure to document everything just like you would on an adult refusal. The next topic I'm going to talk about is assault and battery. So you'll need to know the difference between these two. Assault is unlawfully placing a person in fear of immediate bodily harm without consent. Battery is unlawfully touching a person. I always like to think of battery as with a baseball bat. So battery is you actually physically do something. Oops. And assault is any threat. In Texas, however, assault is actually used to describe both of these. So in Texas, this all equals assault. But in other states, assault and battery are used to describe two different things. So make sure you remember the difference between these two. So I'm going to talk about immunity. In some places, people or organizations or even the government are immune to certain laws and certain risks, basically. There are always risks with treating patients and taking care of patients. So the government is generally immune to things like lawsuits or particular types of damages. There are also Good Samaritan laws for bystanders, for people doing like CPR, for example, or who help in case of emergency but maybe aren't trained. They're just trying to help. These laws generally, however, don't apply to us if we're on duty. We're still subject to negligence and having to do our job. They don't prevent lawsuits, but it does offer a defense for those who act in good faith and meet the standard of care. It does not, however, protect against gross negligence. Remember, this is the one where you act with malice. And I just use another abbreviation here. C with a line over it is the medical abbreviation for with. You'll see a lot of people abbreviate it like that, but this is actually the technically appropriate abbreviation. So when you act with malice. Some patients will have living wills or advance directives. Patients have a right to determine what happens to them. Living wills and advance directives will generally be presented upon patient contact, and if not, then you need to ask for a copy of it. So you have to see it. You need to determine its validity. Is it signed appropriately? Is there a more recent version? That's a tough one to determine. You have to just kind of talk to the family and see. And admittedly, these living wills and advanced directives are generally directives, and it says at the top, directive to physician. Well, we're not physicians, and even though we operate under some of them, it doesn't mean that we can make those decisions. So if a patient presents you with an advanced directive, and you believe that it's pertinent to your current situation, i.e. maybe the patient's in cardiac arrest, and they have an advanced directive that says they don't want any extraordinary measures taken, then you need to get on the phone with your online medical control, and you need to ask, what do I do? There are also some field documents, and these are called DNRs, or Do Not Resuscitate Orders. So you can see this is a DNR. This says DNR. Of course it says DNR. A DNR, like I said, is do not resuscitate, and that generally means no CPR. And if the patient has no pulse, then no artificial ventilations. The DNRs are the things that we can respond to outside of the hospital. A power of attorney for healthcare is actually a document that designates an individual to be kind of the spokesperson or to stand in to provide consent or refusal. These are common in critically ill patients, although they're not exclusive to critically ill patients. I could go designate a power of attorney if I wanted to do so. Power of attorney is the stand-in. In the case that, for example, I became unable to make medical decisions, I could have a power of attorney for healthcare who would make those medical decisions for me. So let's talk more about these do not resuscitate orders. So it's a document, it's an 8.5 by 11 piece of paper, and there are a bunch of little boxes on it. There's actually 4 different boxes, and I will pull one up and I'll put it in D2L for you to see. But take a look at it. The boxes have some kind of quirks to them. So there's some signatures that you have to have in particular areas. So there's basically boxes A through D, and only one of the boxes A through D will be filled out. And there has to be a signature in either box A, B, C, or D. And then at the bottom there's a place for everybody. There's a place for a physician signature, and there's a place at the bottom where everybody has to sign a second time. So everybody who signs it has to sign twice. There has to be a physician signature, and there has to be 2 witness signatures for it to be valid. Now, once it's valid, we can still refuse to honor this. If the patient is pregnant, the DNR is not valid. If there are unnatural or suspicious circumstances surrounding the death, then it's not valid. If the form is not signed twice by all who need to sign it, or if it's filled out incorrectly, or not signed by a doctor, then it is not valid. The MD signature, the doctor's signature, is important because that is what gives us the legal ability to not resuscitate, to not initiate care. We have to have an order from a doctor to not initiate care, and that's what this DNR is. Do consider the family reaction, just be prepared for it, but honor the patient's wishes. If you're in doubt, treat, and you can always treat with the BLS care and call a doctor, and then you can always discontinue efforts if that changes.